Welcome to the deep dive. We're here to cut through the noise and really focus on the knowledge that matters. And today we're tackling something pretty serious. It's a blind spot, maybe even a dangerous one, in the world of civilian self-defense firearm carry. Because the core reality, the absolute bottom line when you carry a firearm, isn't just about how fast or accurately you shoot. It is entirely, completely about legality. Yeah, we've gone through a stack of sources for this deep dive, and they all seem to point to this stark idea: skill without law is a trap. Hmm. It seems we're creating this situation where, thousands of citizens are technically skilled shooters. They've put in the hours at the range, but they're legally, well, ignorant. And this makes them vulnerable, not necessarily on the street, but definitely in the courtroom later. So our mission today is to figure out why this gap exists, what the real stakes are, and frankly, how firearms training needs to change to fix it.
That's right. And just to set the stage properly, let's be clear about what use of force even means. It's way broader than just pulling a trigger. It covers really every level of defensive action. Could be just creating space, maybe a verbal command, all the way up to obviously using deadly force. And this whole framework, the rules you have to play by, it's dictated by this huge, complicated mix of state laws, court decisions, which are always changing, and sometimes even, policies that differ from one county prosecutor to the next. So if you only know the mechanics of shooting, you honestly know almost nothing about defending yourself legally.
Okay, right. Let's unpack that a bit. If the legal stuff is the absolute foundation, what are the core concepts? The non-negotiables every civilian needs to grasp. Before we dig into why training often skips the law, we need to know the actual rules of engagement, so to speak.
Well, what's interesting is that even though the details vary wildly, and I mean wildly from state to state, most places build their self-defense justification on a similar kind of structure. We can probably boil it down to three main pillars that any prosecutor, any jury is going to look at very closely. First off, there's imminence. This means you have to be facing an immediate threat of unlawful harm. Right now, critically, it can't be something that might happen later or, payback for something that happened 5 minutes ago. If the threat's gone, if the person is running away, force generally isn't justified anymore under this pillar.
Okay, imminence, got it. Happening right now. What's next?
Second is proportionality. Your response, the force you use, it has to match the threat you're facing. And this is where, honestly, a lot of people get into trouble. Because deadly force, that's force likely to cause death or serious bodily injury, is only okay legally against an imminent threat of death or serious bodily injury. So the classic example, someone stealing your car and driving off, that's generally a threat to property, not life. Shooting at that car, usually that's a clear case of disproportionate force and probably not imminent either.
Yeah, and I imagine in the heat of the moment, that distinction, life versus property, can get blurred really fast.
Which brings us to the third pillar, I think, reasonableness.
Exactly, reasonableness. This hinges on the reasonable person standard. It's objective, or it tries to be. The question isn't just, were you scared? It's, would a jury believe that an average rational person in your exact situation, knowing only what you knew at that moment, have made the same call? It's meant to take pure panic or subjective fear out of the legal equation and look at the objective facts. Okay. That seems like the one where people could really get tangled up. Confusing how they felt, maybe panicked, with what the law considers reasonable from an outsider's perspective. And this idea of reasonableness, it also connects to those big state differences we hear about, especially around retreat, right? You have the duty to retreat states.
Right, where you generally have to try and get away if you could do it safely.
Versus the stand your ground states.
Exactly, where there's generally no legal requirement to retreat from a place you're legally allowed to be before using force.
That difference alone is huge.
Oh, it's massive. And that's really just the tip of the legal iceberg. You've also got special doctrines layering on more complexity, like the Castle Doctrine. It usually gives you stronger legal protections if you're defending yourself inside your own home. Often there's a legal presumption that someone breaking in poses a deadly threat. But then how states handle defending other people varies a lot. And defending property outside the home, that's all over the map. The main point really is this. Your legal justification can completely change the second you drive across the state line. Florida isn't New York. Texas is definitely not California.
Okay, so given that incredibly complex, state-specific, constantly shifting web of rules, why the gap? Why do so many standard civilian firearms courses, often taught by really skilled shooters, just give that vague warning, know your local laws, and then immediately go back to drills on the firing line? If the law is literally the difference between going home and going to prison, why isn't it front and center?
Well, that is the dangerous gap we're talking about. And the sources we looked at point to basically four big reasons why legal instruction often gets pushed aside. They kind of reinforce each other. The first one, like you said, is just the sheer complexity and localization of these laws. It's daunting. Instructors know they can't possibly teach the specific nuances for every single student's home state, let alone county. Think about just the definition of serious bodily injury. In one state, it might require permanent disfigurement. In another, maybe a broken bone needing a hospital stay is enough. That tiny difference. It could be the deciding factor between a justified shooting and an aggravated assault charge. A general one-size-fits-all course just can't cover that level of detail, so often they just skip it.
Okay, I get that from a practical teaching standpoint, but wow, it leaves the student really exposed.
Totally exposed. Which leads to the second reason, and this one's huge for the training schools. Liability concerns. Instructors are, frankly, terrified of being seen as giving legal advice. If they misinterpret a law, or maybe teach a tactic that later undermines a student's legal defense.
Oh,
Yeah, the instructor at the school, they could face massive negligence lawsuits. So the easiest way to manage that risk, just push all the legal burden onto the student. Tell them to figure it out themselves.
makes sense from their perspective, I guess. What else?
Third is instructor qualifications. Most firearms instructors are certified based on safety, shooting skills, range management. Many are fantastic tacticians, maybe ex-military, former police.
Right, experts in handling the firearm.
Exactly. But they aren't lawyers. They don't have law degrees or licenses. So they correctly stay in their lane, which is teaching how to use the tool, not the complex legal framework for its use.
And the final piece sounds like it might be just business reality.
Pretty much. Insurance and marketing.
Very
A
good.
lot of liability insurance policies for firearms training facilities either restrict legal instruction or make it very difficult, viewing it as a higher risk activity. And then there's the customer side. Let's be honest. Many people sign up for a weekend course wanting to shoot. They want that hands-on time, the immediate feedback of hitting the target.
Not a law lecture.
Not a 2-hour deep dive into the state penal code, no. Schools worry, probably rightly sometimes, that too much legal focus will scare away customers who just want to improve their marksmanship.
So, all these factors combine.
And the result is you have an industry that's often producing civilians who feel confident with the gun in their hand, but they have this dangerous false sense of competence about the real fight, which is the legal one. They're ready for the range, sure, but they're completely unprepared for the questions at the police station or the scrutiny in a courtroom.
That's the core problem, isn't it? And the fallout from that gap, the consequences, they go way beyond just maybe facing criminal charges, right?
Oh, absolutely. If you get that judgment call wrong, misjudge imminence, use disproportionate force, yes, you're potentially looking at serious criminal prosecution, manslaughter, maybe even murder charges.
Which is life-altering, obviously.
Completely.
Mm.
But even if somehow you avoid criminal charges or get acquitted, the fight is often far from over. Almost guaranteed, you'll be facing civil lawsuits. The attacker's family or their estate can sue you for wrongful death or negligence. And our sources really hammer this point. The legal fees just to defend yourself in civil court could easily run into six figures, hundreds of thousands of dollars.
Whoa. Just for the defense lawyers?
Just for the defense. They don't even need to prove you committed a crime in civil court. The standard is lower. They just need to convince a jury it was more likely than not that you acted negligently. So even if you ultimately win the civil case, the cost of simply defending yourself could bankrupt you.
So the law isn't just about staying out of jail, it's about financial survival too, which makes it clear. There has to be a shift in how training is done. It can't just be about hitting targets. It has to be about building lawful decision-making skills, especially under that extreme stress. The sources mention integrated models, like something called Valor Tech. What are these trying to do differently?
Yeah, models like Valor Tech. I think it stands for Valued, Legally Aware, Responsible Tactical Engagement Capability. Quite a mouthful. They're built on the idea that legal compliance isn't an afterthought. It has to be a core tactical variable, just as critical as your sight alignment or trigger control. They operate on the principle that if you wait until the middle of a crisis to start thinking about the legal rules, you've already waited way too long.
You need to have internalized it beforehand.
Precisely. So comprehensive training really needs to integrate probably 5 key components. And it's crucial to always emphasize this is about building legal awareness and decision-making frameworks, not giving legal advice. That disclaimer is key.
Okay, what are the components?
First, you need a solid legal awareness briefing. And it has to go way beyond just mentioning those three pillars. It needs to cover the specifics of that state's self-defense laws, clear definitions of deadly versus non-deadly force, any important local doctrines like castle doctrine or stand your ground. And importantly, it should basically assign homework, tasking students with identifying and ideally retaining personal legal counsel before they ever need them.
Okay, so it's proactive. You leave the class knowing you need to get your legal ducks in a row.
Exactly. Second, and this is absolutely critical, force-on-force training with legal review. Forget just shooting at paper.
Scenario-based stuff.
Yes. Realistic scenarios using role players, maybe simunitions, where the student faces dynamic situations. They have to decide, do I de-escalate? Do I try to escape? Do I draw my weapon? Do I use force? And then the most important part is the after-action review, the debrief. It must explicitly connect every choice the student made, every word, every movement, back to the legal standards. Was it imminent? Was it proportional? Was it reasonable?
Connecting the tactics directly to the law.
Every single time. Third component, intensive training on communication skills after the incident. Because the fight doesn't end when the immediate physical threat stops. Far from it. Students absolutely need to know how to call 911 effectively. What information is crucial to give, location, description of threat, ensuring medical aid is coming, and maybe even more importantly, how to interact with the first police officers who arrive, what to say, and critically what not to say.
That seems vital. What's the key there?
You need to clearly identify yourself as the victor, point out the attacker if possible, point out any evidence or witnesses, but then stop talking. You provide the essential safety info, but you absolutely do not give a detailed statement, a play-by-play of what happened, while you're still pumped full of adrenaline and haven't spoken to your lawyer.
Because anything you say can and will be used against you, right?
Yeah.
Even if you think you're explaining why you were justified.
Exactly. Officers are there to gather evidence, and your potentially confused, adrenaline-fueled statements can easily be misinterpreted or used to build a case against you later. Secure the scene, identify yourself, then invoke your right to remain silent until your attorney is present.
Okay, communication is key. What's number 4?
Fourth is post-incident planning. This is more logistical preparation. It means encouraging students to actually set up that legal support network in advance. Have an attorney specializing in self-defense on speed dial. Consider getting self-defense legal insurance or joining a legal defense plan and understanding basics like not contaminating the scene, identifying witnesses for the police. It's about having a plan for the immediate aftermath.
Thinking ahead for the chaos.
Right. And finally, number 5, to make all this sustainable for the training industry itself, you need robust instructor protections. This means clear, unavoidable disclaimers built into everything. On the website, in the course materials, verbally stated in class, this course provides information about legal principles but is not legal advice. Laws vary significantly by location and change frequently. Consult a qualified attorney in your jurisdiction for advice specific to your situation.
Covering themselves legally while still providing the education.
Precisely. It protects the school and instructor from liability while still empowering the student with crucial awareness.
Okay, so implementing all of that, it sounds like a much more comprehensive approach, but I can already hear some pushback, people saying, thinking about all this legal stuff is just going to slow me down when seconds count. How does integrating this legal context actually make someone a better, maybe even faster tactician in a real crisis?
That's a common misconception. But it actually works the other way. It creates clarity and efficiency, not delay. When you've trained not just the how, but the when and if, according to legal standards, you fundamentally change your decision-making process under stress. It's not about consciously running through a legal checklist in the middle of a fight. It's about having drilled the boundaries so deeply that your subconscious recognizes faster when options other than deadly force are viable, preferable, and legally sound.
So it helps you sort options faster.
Yes. You recognize more quickly when creating distance, using verbal commands, seeking cover, or simply disengaging are not only safer tactically, but also legally superior choices in that specific moment. It helps you develop the mental speed to navigate that very narrow legal channel for justification while under duress. You're not freezing, you're filtering options more effectively.
And it gets you to that critical distinction.
Absolutely. The crucial distinction between can shoot, meaning you possess the physical skill to hit the target, and should shoot, meaning using deadly force, is legally and ethically justified in that instant. Integrating the law is what defines a truly responsible armed citizen, not just a technically proficient shooter.
That really is the essential mindset shift needed. So for anyone listening right now who might be considering firearms training or maybe reevaluating the training they've already had, you need to protect yourself legally even before you sign up or pay for a course. What's the absolute baseline question they need to ask any potential trainer or school?
If you're investing your time, your money, and potentially betting your freedom on this training, the very first, most fundamental question you have to ask is this. Do you incorporate scenario-based force-on-force decision-making training, where I will be forced to choose between different levels of response, including de-escalation, retreat, and the use of simulated force? If their answer basically amounts to, no, we primarily focus on live-fire drills on the range, then you know right away you're only getting half the training you need. Maybe less than half.
Okay, that's the gateway question. Assuming they say yes to scenarios, what are the next key follow-ups to gauge if they're offering legally responsible training?
All right, 3 more crucial questions. First, does your course curriculum include a specific overview of my state's self-defense laws and doctrines? Things like stand your ground, duty to retreat, castle doctrine as they apply here. If they only give a generic federal overview or a vague disclaimer, that's not good enough.
Needs to be state-specific. Got it.
Second, do you provide dedicated instruction or discussion on what happens after a potential shooting incident, specifically covering the 911 call, how to interact with arriving police officers, and basic evidence considerations?
Planning for the immediate aftermath.
Yes. And third, this one's often overlooked. Do you provide any resources, guidance, or even contact information for finding qualified self-defense attorneys or legal defense plans available in my local area?
Helping you build that support network?
Exactly. It shows they understand the full scope of the student's responsibility.
So if a training presider answers no to those 4 key question scenarios, state law, post-incident legal resources, what does that tell you?
It tells you they are primarily selling you technical shooting skills, which is fine as far as it goes, but they are not adequately preparing you for the immense legal accountability that comes with carrying and potentially using a firearm for self-defense.
They're leaving you legally vulnerable.
Precisely. And look, the training industry is starting to wake up to this. Slowly, maybe, but there's a growing recognition that just teaching shooting skills without the legal context borders on negligence when you're dealing with deadly force. The future, the responsible future, involves building these comprehensive legal awareness modules and stressing legal accountability right alongside marksmanship and tactics, because ultimately, use of force isn't some abstract theory. It is the cold, hard, real-world framework that will determine whether you walk free or spend years, maybe the rest of your life, navigating the legal system.
Yeah, the main takeaway here couldn't be clearer. Your training, your preparation, it absolutely must get you ready, not just for the range, not just for a potential street encounter, but also for the incredibly harsh environment of the courtroom. Anything less just isn't complete. It leaves you dangerously exposed.
Which brings us to maybe a final thought for you, the listener, to really mull over. Think about this. A firearm is the absolute last resort. It's the final tool in a very long, very complex chain of decisions and actions. If you're diligent enough, responsible enough to invest time and effort in training for accuracy and technical skill with that tool, you absolutely must be just as rigorous, if not more so, in training for legality first.
Because when the immediate danger passes, when the smoke clears, the fight to save your life, your freedom, your future, that fight continues and it takes place in court.